Yeah, so the state Supreme Court made a decision involving a planned unit development in Telluride. That's basically a mixed-use property that includes things like condos and apartments and shops and stores together. There's also a planned unit development that's been in the works in Greeley until voters put a pause to that. Right now, this is what the land near County Road 17 and Highway 34 in West Greeley looks like. It was becoming home to the Cascadia development, which would include a hockey arena, water park, and hotel. But the spokesman for this project, Bill Rigler, says it has been on pause since February, when Greeley voters repealed city-approved zoning changes required for the development.
The Greeley voters spoke and said, we want to delay this project.
This week down in Telluride, Colorado Supreme Court's unanimous ruling said people cannot vote to change a planned use development agreement because that's an administrative, not a legislative decision. Supporters of the Cascadia project say that reasoning should also apply to Greeley special elections.
Showed what we've argued all along, that special elections on land use decisions like this are not constitutional.
Rhonda Solis with Greeley Demands Better, a group opposing the project, says it should not.
I mean, basically it's saying any kind of amendment made to a PUD is kind of where this comes into play. And that's not even close to what our situation was. This was about actual original zoning.
9 News' legal analyst Scott Robinson, who's not connected to either case, weighed in.
People who support the Cascadia project now have a leg to stand on, but it's a pretty shaky one because this is a original zoning decision, not an amendment, such was in the case before the Supreme Court in the Kavanaugh versus Telluride decision.
Bottom line,
this is a difficult decision, as the Supreme Court has acknowledged.
Greeley city leaders weren't available for comment, but they said they're still reviewing this ruling. In Greeley, Amanda Gilbert, 9 News.